In today's episode, we'll be talking about
the smell that comes from smoking marijuana is not enough probable cause for police to search a vehicle.
The Illinois Supreme Court rules in what now becomes the law of the land of Lincoln. Police will not be allowed to search a vehicle based solely on the smell of burnt cannabis.
The Illinois Supreme Court made that ruling yesterday, citing the changes in the state's cannabis law, which was legalized nearly 5 years ago.
To do that, I'll be joined by legal experts that are refined in the details of this case. It may go without saying, but nothing in today's episode should be constituted as legal advice. Enjoy the episode.
I'm Cole Preston, and today I'm at Blue Island Beer Company for the premiere of my mini documentary on legalization policy in Illinois. I've been following cannabis policy since colorful Colorado legalized it all the way back in the day, and when my home state of Illinois decided to legalize it, I just became enamored. I wondered, what would it actually look like? If you'd like to see how Illinois fell short in achieving meaningful reform in their cannabis policy, you can watch my mini doc now at colememo.com/minidoc.
All right. Thank you, folks, for tuning in to the Cole Memo. Have you been seeing all of the smoke around the Illinois Supreme Court's ruling on the odor of burnt cannabis? Today, we'll be breaking down how we got here, what the decision means, and of course, the big picture thing is the fact that there are some questions that remain, and future rulings could still shift policy and the discretion that law enforcement has in interactions that we have with them. To help us understand, I'm joined by two legal experts. Attorney Bruno, welcome back to the show. Can you please introduce yourself to my audience?
Thanks, Cole. I'm Evan Bruno. I'm with Bruno Law Offices in Urbana, Illinois, where I specialize in criminal defense, including cannabis cases. You can find us at brunolawoffices.com for any criminal or traffic cases. And this is kind of a pet interest of mine. So happy to be here. Thanks for having me back.
Yeah. And Attorney Bob Galhotra, thank you for joining me back on the show. Please introduce yourself to my audience.
Hi, Cole. Thanks for having me back. I'm Bob Galhotra from Galhotra Law. I specialize in criminal defense law. I've been a Cook County lawyer for 34 years, and for the last 4 years, I've been going to other parts of the state as well. I'm also a adjunct faculty member at Chicago-Kent College of Law.
Well, I want to thank you both for your time and more importantly, for what you do. Attorney Bruno, do you want to kick us off with a recap of how we got to where we are today and what we're even talking about?
Sure, thanks. So the question, the big question here is when an officer smells cannabis in a motor vehicle, can the officer search the vehicle based on the smell of cannabis? That's a very big question. And then that question kind of can get broken down into smaller questions within questions, which is what we're going to talk about today with this new Supreme Court case. Just zooming out even further, the Fourth Amendment protects people from unreasonable searches and seizures. It's been long held throughout the entire United States from a Supreme Court decision that a vehicle is special because they can move around, and they're often police often encounter vehicles on the roadway when they can be moved. The Supreme Court held long ago that the police don't need a warrant to search your vehicle. All they need is probable cause. If it's your home, they need probable cause, and then they need to take the probable cause to a judge and get a warrant to search your house. The warrant doesn't apply to vehicles, so police can search vehicles if they have probable cause. What is probable cause? It's basically a good reason to think that there's evidence of a crime inside whatever they want to search. And so if it's your vehicle, the police need some good reason to think that if they search your vehicle, they'll find evidence of a crime. So that's the basic overview. Back before 2013, and this is laid out in the Supreme Court's recent case of Redmond that we're going to talk about today. Back before 2013, there was no such thing as any legal cannabis in Illinois. And so it was very simple. If the police officer smells cannabis, whether it's burnt, raw, whatever, that's enough reason to think that there might be evidence of a cannabis crime in your car. And so the police can search without a warrant and they can just toss your car. 2013, Illinois became a medical cannabis state. And so that question became a little murkier. If an officer smells cannabis in a vehicle, is that good reason to think that a crime's been committed? Maybe the person has lawfully used or possessed cannabis. So the question became a little murkier then. Fast forward to legalization, and we now have this question of if an officer smells cannabis, is that good reason to think that the person's committed a crime? When marijuana was recently legalized, I say recently, but it's been a few years now, the bill was passed in 2019 and went into effect January 1st of 2020. At that same time, the legislature added a new rule to the vehicle code that makes it a crime to transport cannabis in a vehicle not in an odor-proof container. So if an officer smells cannabis in your vehicle, well, I'm oversimplifying, but the theory goes, if an officer smells cannabis in your motor vehicle, the only reason he could smell that is if it is not in an odor-proof container, which would be a criminal offense. So the officer can search the vehicle for evidence of the crime of having the cannabis in the wrong container. Side note, that odor-proof language was added at the behest of the Sheriff's Association, law enforcement lobby, essentially, because God forbid the legalization of cannabis took away the tool to allow officers to search vehicles based on the smell of cannabis, because the smell of cannabis has gotten a lot of police into a lot of cars. And so they didn't want to lose that tool. So they added the odor-proof language. Now is where the question kind of splits in two. If an officer smells cannabis coming from a motor vehicle, as the driver rolls down the window on the side of the road, there's now this question of, well, if you smell burnt cannabis, meaning maybe your jacket smells of burnt cannabis or the interior of the car smells of burnt cannabis, well, that's not the logical syllogism doesn't necessarily work now that you must have cannabis that's not in an odor-proof container, because the officer theoretically is smelling the shadow of cannabis. Cannabis is gone. There's no cannabis in the car. The officer is smelling smoke, essentially, the smell of burnt cannabis. And so therefore, it's not necessarily probable cause to get into the car. When the Supreme Court took up this question, they accepted two cases for review. One was a case out of the 4th District called Molina. The other one was the case that they just decided the other day called Redmond. And that was out of the 2nd or 3rd District.
It was out of the 3rd.
3rd. Thanks, Bob. So Redmond from go had to do with burnt cannabis. The officer said, I smell burnt cannabis. And the guy was nervous, and he was coming from Des Moines, which is apparently a high crime city, according to the cop. Obviously, that's the reputation everyone thinks of when they think of Des Moines. They think of this high crime area. That's sarcasm. But then also the guy's driving on a drug corridor. And by that, he meant Interstate 80, which is one of the busiest roads in the whole state. And so he searched the car, but primarily based on the smell of burnt cannabis. The other case, Molina, was a case where the officer said, I smell raw cannabis. And the appellate court in Molina said, that's okay to search, because if it's raw cannabis that you're smelling, then it must be giving off an odor that you can detect. And if you can detect the odor, it's not an odor-proof container, so you can search. In Redmond, the appellate court said the odor of burnt cannabis is not enough. These other factors that the officer pointed to, not enough. Invalid search in Redmond based on burnt cannabis. 4th District appellate court said valid search in Molina based on raw cannabis because it must not be in an odor-proof container. The Supreme Court took both those cases to review at the same time. They heard oral arguments in one sitting for both cases, and the Illinois Supreme Court released its decision just a few days ago in Redmond, the burnt cannabis case, and said smell of burnt cannabis alone is not sufficient probable cause to search a car. And they got there by basically saying that this cop in Redmond, this other stuff he pointed to, the guy was nervous, he was coming from Des Moines, that's not enough to get you into the probable cause territory. And now we await the decision of Molina, and we'll get into this a little bit later, but theoretically the Supreme Court's going to couch that one in terms of the odor of raw cannabis, and we'll have to wait and see what they say in that case. So that's kind of how we got here. I left a lot of important stuff out, but I think for purposes of this conversation, that kind of gets us to where we need to be to start our discussion on this topic.
Yeah, and Bob, I'll pass it over to you if you have something to say. But I just want to say I'm really glad we're having this conversation because, there was some early reporting on this issue that caused a lot of people to celebrate, I think, a bit prematurely. They thought both of these issues were being addressed when Attorney Galhotra, as you're about to probably make clear, the Supreme Court made very clear in their ruling that they would be ruling on the Molina case separately. So I'm glad that we can come together to have this fact-based discussion because, frankly, I think we're dealing with enough confusion and apathy around cannabis policy in and of itself. It's something we talked about last time. I'm like, how can we get energy behind homegrown and stuff like this? Because people are just like, it's legal. What's the big deal? So we're dealing with enough apathy. So I think it's important to, like I say, make it clear what they've ruled on and what they haven't ruled on. With that, I'll pass it over to you, Attorney Galhotra. Anything to add or take from there?
Yeah. Yeah. Thanks, Cole. As Evan gave a really great background history of the cannabis law and how the Fourth Amendment applies to vehicle searches. And the Supreme Court seems to have gone ahead and continued with this dichotomy between burnt cannabis and raw cannabis. Redmond did involve burnt cannabis, but I have this section regarding the actual observations regarding that in the case. And I'm quoting from paragraphs 8 and 9. And here, this was the testimony that came out at the hearing on the motion to suppress. When Combs, the officer, approached, he smelled the odor of burnt cannabis emitting from the vehicle during the state's examination. Combs testified that the odor was very strong. He also testified he asked Redmond, the defendant, about the odor, and Redmond denied having smoked cannabis in the vehicle. His examination of the vehicle didn't reveal anything that was lit or currently emitting an odor of cannabis from the vehicle, so nothing smoking. Combs was also agreed that he did not see any cannabis in plain view. Combs had Redmond come out of the vehicle, seated him in the squad car, and then Combs could still smell the odor of burnt cannabis in the vehicle, but he couldn't recall smelling the odor of burnt cannabis on Redmond's person. And Combs admitted he saw no signs of Redmond being impaired. So Redmond didn't look stoned. He couldn't find any pipes or any lit joint or anything like that. The car smelled of burnt cannabis, but he couldn't tell whether it was coming from him or the car or what. And then they find raw cannabis in here. The arrest is for raw cannabis. So the judge rules that, this is not reasonable. This is not probable cause to search the vehicle and find the raw cannabis and find and charge somebody for possession of cannabis in a motor vehicle. So it's suppressed, and the Supreme Court, as you know, as Evan just explained, said that under the totality of the circumstances, the smell alone is not enough, and the other reasons the officer gave weren't very good either. But having said that, they made it very clear that they weren't talking about raw cannabis. And there's a particular footnote where they bring out in Redmond, the Supreme Court says, I think that's it. Redmond does not contest the validity of the odor-proof container requirement in Molina, a case dealing with an officer's detection of the odor of raw cannabis coming from a vehicle. We address the validity of the odor-proof container requirement. So here we go, putting on our getting my crystal ball out and speculating on what the Supreme Court's going to do. One, what it could do is it could go along with the argument that was presented by the defendants, by the appellees in the Molina case, because they won below, but the appellate court, Justice Steigman, reversed the motion to suppress. And there they argued that when they amended the Cannabis Control Act and the Compassionate Use of Medical Cannabis, the Medical Act, when they did that, they implicitly had to have taken out the odor-proof requirement because it's just not consistent. They could read that into the law, but I really, really doubt it. A lot of times what the Supreme Court will do is say, hey, legislature, this is the way you wrote the law, it's on you to change it. We're just interpreting what you wrote. And that really is sort of the gist, I think, of the appellate court in the Fourth District and the way they presented it. In Molina, um, Justice Steigman says that an officer who smells cannabis in a vehicle he has just stopped is almost certain to discover a violation of the vehicle code, that provision that says it has to be in an odor-proof container, because the law clearly states that when cannabis is transported in a private vehicle, the cannabis must be stored in a sealed, odor-proof container. In other words, the cannabis should be undetectable by smell by a police officer. So those are the two possibilities that I'm seeing. Either they've got to say, hey, legislature, it's on you, go ahead and change that part, right? Or they're going to have to say that, we're going to read into the law that this odor-proof requirement is not really availing. And one of the problems was, in Steigman's opinion, he not only agreed that the statute itself still required it to be odor-proof and it was still on the books, but he also said the judge went out of his way to say, well, it could have been this or it could have been that. It could have been a guy that works at a cultivation center, and so now he smells like raw. And he also kind of posited the theory that, there's a lot of ways that people could smell. He basically went out and considered things that were never presented in testimony at the hearing. So it could be the Supreme Court will give a green light to, hey, based on this record, we can't do it, but why don't you guys go out there and put some experts on and have them testify? We're not telling you what to do, but if we had the facts in front of us, maybe we would look at this differently. So, there is a big economic aspect to this, of course, because it's a multi-million-dollar industry in the state of Illinois. And if there are large amounts of raw cannabis being transported on the interstate highways, the government wants to, and I think the judiciary is going to allow the government to have some say and control over that. The interesting thing is this applies to passenger vehicles. So we're not talking about large semi-trucks loaded with weed where they really don't have kind of expectations like that. You can't put a dog on it. They're not allowed to have any of that kind of stuff. Some of the laws are different on commercial transport, but this is going to affect private movement of cannabis among states as well, and small scale stuff.
Yeah. Attorney Bruno, did you have anything to add on that?
I totally agree with what Bob said. It's I could not have better articulated, I think, the possibilities as to what the Supreme Court might say in the Molina on the odor-proof container requirement. I think the most likely thing they're going to do is affirm the Fourth District's decision where it said, we're talking raw cannabis and you can smell it. It's not in an odor-proof container. That's easy. I don't think they're going to bend over backwards to make it easier for people to transport cannabis or kind of interpret the implicit overruling of the odor-proof container requirement. It's not like that's some ancient law that's been around since the 20s and that people forgot about and then they legalized cannabis. This is a new law that was passed alongside the legalization of cannabis. If you're the Supreme Court, you have to assume that the legislature knew what it was doing when they chose to put the word odor-proof in the law. So I think that kind of sets us up right now for this. The tale of two cases here is raw cannabis versus burnt cannabis. My hope when they took these cases is that this wouldn't all hinge on some cop saying, trust me, I smelled raw cannabis, or trust me, I smelled burnt cannabis. But just looking at Redmond, I think it's maybe the first, so the very first sentence of Redmond, whether a police officer's detection of the odor of burnt cannabis is probable cause. And they could not be more clear threw out this opinion that we're talking about burnt cannabis here. We're not talking about raw cannabis. So just looking at half the picture here, just looking at this one opinion and not the other opinion, I don't know how they could possibly now decide Molina and say in Molina, well, it's kind of not really reliable to have cops making the distinction between burnt cannabis and raw cannabis. They clearly, based on Redmond, think that police are equipped and can be trusted to testify accurately about whether the smell that they smelled was burnt cannabis or whether it was raw cannabis. So they're kind of just saying, if a cop says he smelled burnt cannabis or if a cop says he smelled raw cannabis, we'll just take that at face value and proceed accordingly, which I think that's going to be the problem.
And it's kind of silly because when you look at the facts in Redmond, right? I mean, the cop is smelling burnt cannabis, but they discover raw cannabis.
Right. And no roaches,
So, I mean, how reliable is that? Either, but yeah, definitely they're going down two different roads now.
Well, and what I was thinking about, Bob, and you might have some thoughts on this, is I'm kind of fast forwarding to a potential hearing on a motion to suppress evidence. And the question to ask the officer is, can you, a series of questions aimed at, can you describe the difference in odor between burnt and raw? What day was it at the academy where they gave you training on the difference between the smell of burnt and raw? Do you personally smoke cannabis? Do you have, how have you been taught a smell? Who taught you what smells, whether the smell is burnt and what the smell of raw? And if I was running the police academy, or if I was making sure that my deputies were up to speed and well trained and well prepared to justify their searches, I'd probably start having sessions where we burn some cannabis and everyone gets to smell it, and then we take some raw cannabis and everyone gets to smell it. Maybe they do that now, but what it looks like the Supreme Court is setting up here is it's now going to be critically important in any cannabis odor search case for the cop to be able to persuasively tell the judge, no, I smell raw cannabis and I know the difference.
Yeah.
Just fraught, because you can't capture that on a body cam video. It's one of these things where it's usually just trust me, I know the difference, Judge.
And I want to pass it over to you, Bob, but to that point, just to illustrate it a little bit, maybe for listeners that don't understand, with other crimes, let's say I got into an altercation on the motor. I'm going to give you an extreme example. I got into an altercation, which ended up with me throwing somebody at another person's vehicle. So not only do they have this on footage, but they have like photo evidence of the damage I did to their car. These are things you can bring into the courtroom and prove your case, even though you may not have seen it for yourself. You can't really pull a vehicle into the courtroom and have the jury come over and be like, or, the judge, I guess. It's just not like a replicable, for lack of better words, crime, Like you said,
it's not something that you can demonstrate, like a photograph or, showing a video or playing a tape or even showing some sort of scientific measurement, like a urinalysis indicating the level of alcohol or something like that. There's no objective really way of doing it. Unfortunately, in some districts, there are cases which hold that probable cause, I'm quoting from People versus Williams, a 2013 case, based on the sense of smell may not be as those where probable cause is based on what's visually observed. Those involving, quote, an individual sense of smell can be the most persuasive character, particularly in cases involving cannabis. And that was a little quotation from the People versus Hill case. And, Hill was another Supreme Court opinion. That was the one that came out after the Medical Act was approved and after decriminalization, but before it was legalized recreationally. So there was this Stout case, which had to do with the smell of cannabis, burnt cannabis, and then there was also Hill, which had to do with the smell of cannabis as well. And in Hill, I think they found cannabis and cocaine during the search, a small amount, not a large amount.
And that's a small point. I want to try to do a brief recap of where we stand right now, but that's a small point I wanted to just make as well. You just pointed out, Illinois decriminalized in 2016. Evan, an example you had given me in the past is like if, for example, I had this joint and it wasn't half smoked, it was a full joint, and I had it in my front pocket, then it would have been, hey, Cole, it's decriminalized. That's a citable offense. What are you doing? $100 to $200 citation, get out of here, but now it's if I have a joint in my front pocket or just not in an odor-proof container, it is a Class A misdemeanor with up to a year in jail and prison, possibly, and fines. Am I correct on that? Like in the difference?
You're up to 364 days in jail. Yeah. So just one more example of it's in a lot of ways easier to get in trouble for cannabis now than it was before they legalized it.
Mm-hmm.
So if this is a good time, just another thing that's actually just occurring to me right now is how problematic it is to draw this very important legal distinction between the odor of burnt cannabis and raw cannabis. Burnt cannabis is almost a little old school. A lot of people who use cannabis now use a vape pen or a vaporizer that doesn't burn it with fire. And it might also have some blueberry flavor in it. And the smells, it's not this binary one smell and then another smell. There's kind of a continuum there. And so if someone's driving down the road, and they hit a resin vape pen that doesn't have flavor in it, it might smell exactly like raw cannabis. And so it's just that it's when I said before this came out, I'm worried they're going to screw this all up. This is kind of what I was worried about. This kind of naive foundation upon which they're building this important Fourth Amendment decision. And it's just this idea that not only is there's only two cannabis smells that it can exist, burnt and raw. And then the silliness of thinking that, Joe deputy from some rural county on the interstate, on some side of the road is going to be able to tell the difference. It just seems like it's short-sighted. And one of the problems is that the Supreme Court took a case that didn't have really good evidence presented in the trial court for either case. I don't think this might have been a case where the Supreme Court should have said, that's an interesting issue, 4th District and 2nd District. We're going to sit back and wait and see a little bit more. Maybe some clever lawyer out there will actually call in an expert, make a record at a motion to suppress hearing, and then we'll be able to actually have some real science or some real facts to make our decision on. But they've kind of been underserved, I think. And I don't want to throw any shade on the lawyers involved at the lower level. I mean, usually it's anticipating that the Supreme Court's going to decide your case when you're at the trial court level. But it would have been really nice to see some expert testimony in one of these cases. It could even be someone who sells, who works at a
dispensary
and says, look, I spend all day, every day at a dispensary. I'm also a personal user. I'm familiar with all of our products and the packaging, and, ask questions and make a record of the fact that, you can buy this stuff in the store packaging fresh off the shelf and it still smells. There are vape pens that burn or vaporize at a very low heat. So it does, there's not like the smokiness incorporated in. So it's kind of indistinguishable. But they went a different route and kind of looked at this as much more simple. So,
yeah, very, very. And I think it's always important to understand, to your point, I wish that one of the, I don't know how possible, this is probably not possible in the court process, but it's like, let's take a field trip. Let's go to a dispensary. We don't even have to buy anything. Let's just step inside and you will smell you will smell the cannabis. And I think an important point that actually not a lot of people know, even like a lot of cannabis users that listen to this show, they're not packing that stuff in the dispensary. It comes pre-packed, which means that it comes in containers that are not odor-proof. I mean, that's just a fact.
Right.
So,
Universally too. Not
mhm.
like 1 out of 10 packages you can smell, but
But
almost all of them are non-odor proof.
I've interviewed canine officers on this show that have worked in the border and also just in the state. There's no such thing as odor-proof container. You can Google it, and don't get me wrong, there are certain containers that do a better job of mitigating smells. But ultimately, a canine, there's just no such thing as odor-proof, and I think that's a big issue with this.
I think there's actually an opinion from the 4th District that says that, well, it wasn't an odor-proof container because the canine smelled it. Literally. I mean, not even like human smell.
Yeah.
I mean, it's even gone to the level of if a dog can smell it, it's not an odor-proof container.
Right. Exactly. Now, I wanted to just ask you both because we kind of got into it, and I just wanted to recap. As we stated, these cases were consolidated. The Chicago Tribune reported, in a somewhat unusual move, the court consolidated 2 cases with opposite appelling rulings on the issue, then severed them for its rulings. So we've established that. Is it our speculation that they've ruled that the smell of burnt cannabis cannot be used in and of itself? But are we thinking that we're not going to see a let's call it a favorable ruling with regard to the odor-proof container? In other words, do you think they're going to say the law is clear, the legislature wrote it the way they did, and this is it?
I think a more interesting question, Cole, is whether they'll issue that opinion before the legislature wraps up its legislative session, because I think Senator Ventura's bill may still be pending, which I think changes the odor-proof requirement. Am I right on that, Evan?
I don't know what the status of that bill is.
But I think there may be some bill still pending that change the odor-proof requirement in the vehicle code, which would be the quickest, easiest solution to the Molina case, and it would resolve the whole Molina issue.
Yeah,
I agree.
And to your point, Evan, I am not exactly sure where it stands right now, but to your point as well, Bob, it was in House Bill 2911, and it aimed to remove the odor-proof container, and it just struck it from the law. I believe, Evan, you were instrumental in creating that language. However, Jim Kychek, a representative of the Illinois Sheriff's Association, opposed this change, arguing it would weaken enforcement efforts. And to address those concerns, Leader Lightford, it was in her bill at the time, she ultimately took it out of her bill. But I do recall a statement being made that, hey, it's in the Supreme Court right now, and depending on what that ruling is, then we can take action. So that's my hopeful silver lining, that if it doesn't go our way, like you just said, Attorney Galhotra, maybe the General Assembly takes the ball and puts it in the end zone, to use a sports analogy.
I don't know if it might have been Alexander Hamilton who, when they proposed the 4th Amendment, said, this is going to weaken enforcement efforts. Well, yeah, it's called privacy. It's called freedom from searches that shouldn't be made because they're unreasonable. But point taken. Yeah. There's a lot of things that weaken enforcement efforts in the name of not letting the government search wherever it wants for no good reason. So
yeah, and not to mention that, in the spirit of some of the amicus briefs that were filed in the Redmond case, there's a lot of black and brown people that get pulled over for this for no reason sometimes. If this is not a good reason, why are those folks getting pulled over? I mean, there's just statistically, there's a demographic that gets pulled over for these types of offenses.
Not to mention, and I'm beating a dead horse here. I've mentioned this every time this topic's ever come up, but it's such a perverted rule in and of itself, just on its face, that it's a law in Illinois that, under penalty of imprisonment, you must conceal from law enforcement the odor of cannabis in your vehicle. If you don't conceal it from the cops and hide it from their detection, you're a criminal. It just reveals how this is not in any way, shape, or form aimed at public safety. It's purely a Trojan horse to allow the police to search your car. If it was aimed at safety, if they really cared about safety, they would say, you can't put cannabis in an odor-proof container. It must be in a container that's not odor-proof, because we need cops, based on the totality of the circumstances, to be able to detect it, but with their nose. And so we're all better off, at least if the cops can know if it's there. But this sneaky snake of a law says, no, if we can detect it, it's a crime. You got to hide it from us. And they know that no one is going to be able to do that. So it's really shameless. And it's just so disappointing to see how just seeing the folding that takes place whenever this odor-proof container rule is proposed to be removed. Well, the Sheriff's Association said that it's going to hamper enforcement efforts, so we just got to take them at their word and move on.
Yeah. If folks want to see,
that's my soapbox.
It's okay. Yeah, if folks want to see that moment, I'll have it linked in the show notes. It's really a two-pronged effort. To your point, Evan, it is, there's a profit motive for these cops to keep that skeleton key. It's called civil asset forfeiture, and it's freaking awesome for them. I'm being sarcastic when I say that. I hope that my listeners know that. Did want to make that clear, though. And then to Attorney Galhotra's point, there's another prong to this profit motive, which is to keep what they consider to be the illicit market at bay. And it seems like this is the only way they know how. It's funny, there's still, I don't know if you knew this, there's still an illicit market for basic staples like milk and eggs. It makes me question whether or not it's even possible. And, if you wanted to make it possible, I don't know if you both, I know you're both on the kind of criminal justice side of this issue a lot, but if they want people to participate in the market, they should make it irresistible to not participate in the market. And by that, I mean, if you look at states like Michigan, like, you're silly if you don't participate in the market because it's just so easy. And yes, the prices are lower and competition is fierce. But if your goal, like you said earlier, Attorney Bruno, is to, reduce unlicensed activity and crime, then making participation in the market irresistible, I think, is key to those efforts. We have these issues with hemp right now, right? Where people are like sidestepping, trying to sell hemp. And it's because they can't do it legally. Oftentimes they can't get the coveted license. I know that's a topic for another show, but again, I think it just lends itself to, there are several profit motives, I think, at play that keep particularly this issue at bay.
Oh, sure. Absolutely. Yeah.
Yeah. I thought what you mentioned earlier, Attorney Galhotra, that, the economic interest of making sure large quantities of cannabis were not being transported was really an interesting one. I never really thought about that element of it. And I know that we've mostly been focusing on the Molina case, but I think it's important, and I wanted to ask you about this. The court did caution in the Redmond case, according to the Chicago Tribune, that police can still consider the smell of burnt cannabis, and this I think seems reasonable actually, can still consider the smell of burnt marijuana as part of the general circumstances that may justify a search. In other words, if you're, speeding and you've got a joint on the center console and they smell burnt cannabis, like there's a lot of circumstances.
Sure.
Yeah.
And you got bloodshot eyes and they're red and you've got dry mouth and you're speeding. Yeah, you're going to get a DUI, no doubt. And there's going to be probable cause for that because under the totality, or, you've got, if it's somebody who's saying they traveled to California 3 days before just to go see the West Coast, for a little vacation. And then they have one-way tickets sitting around in the car. If there's other circumstances, the interview that indicate that, give you rise to probable cause to search, definitely but in this case, in Redmond, what they heard wasn't enough and was easily explained. I think he had been going back and forth to Des Moines during the pandemic, and I think there was some issue about residency. It was resolved in the defendant's favor.
So, but like with the Redmond case, just like a small point that I want to I'm asking this so that people can be careful because people, I think this is important with there being these like hard lines that as Evan Bruno calls it, the tightrope, right? If you're not on the tightrope, then you can still get in trouble. This Redmond got pulled over for going 73. Can they use you speeding in addition to the smell of burnt cannabis? Like that's right? Like it can still.
Totality.
Yeah, it was see, in this case, I don't think the stop was really the problem.
Okay.
There was reasonable suspicion. The issue is whether or not there was probable cause to search. That was the issue in Redmond. And the Supreme Court wound up affirming the appellate court, which wound up affirming the trial court in that this was not enough to form probable cause. The fact that the guy lived in Des Moines, the fact that his license plate was a little tinkered, that he was doing 73 miles an hour, and that, he didn't have his driver's license on him, but when they ran his name, the driver's license was valid, right? So all that stuff checked out.
And I would have been, it would have been the most revolutionary case ever if the Supreme Court had said you cannot consider the odor of burnt cannabis as part of probable cause. I don't think there's anything that a court has ever said you cannot consider. Maybe you can't consider someone's race or religion, maybe something, very taboo like that's protected by the Constitution. But the whole idea of totality of the circumstances is you can consider anything. If the guy smells like cotton candy and, the officer knows that there's a, local gang that operates out of the cotton candy factory, you can consider the smell of cotton candy. There's nothing you can't consider. But what this does, why this opinion overall is a good opinion, I think, but I'm scared of what's going to come with Molina. But just looking at this in a vacuum, this is a good opinion because before this opinion, the prevailing idea, the prevailing law, I guess, was
out
just the odor of cannabis. Just the odor of burnt cannabis is enough. So you could be, have zero factors that raised suspicion. Assuming that the stop is legit. Maybe you're going 71 and a 70 and you're pulled over and it's a old lady going to church, never been in trouble in her life. Everything's up to snuff on the car. Plates are good. Registration's good. But if they smell the odor of burnt cannabis, that was enough before this case. And so this is important. I don't want to diminish it. And I had a lawyer friend say to me, well, they're just going to find reasons now to get into the car anyway. That might be true. But what this opinion does now is say those other reasons have to go through a judge, and the judge has to say that's enough under the totality of the circumstances to constitute probable cause. And this Redmond case itself is a perfect example. The other reasons that the cop pointed to here was, well, he's coming from Des Moines and he didn't have his driver's license on him and his license plate was crooked and, he seemed nervous. Now, with this decision, a judge gets to hear all that and say, not so fast. Those are not enough to bring you up into the probable cause territory. So it's an important opinion. It's just like, it's the calm before the storm, because I'm now worried about what they're going to say about raw cannabis. And I think it might, in theory, this is good, but now we have this distinction between raw and burnt that I feel like is going to be unworkable in a lot of ways on the ground.
Yeah. Any thoughts on that, Attorney Galhotra?
Well, I'm just looking at the anticipated filings. So the next one's October 3rd, and they haven't posted yet. So I'm just hoping that at least on October 3rd or the 18th, the next two anticipated dates for filings, that they announce the Molina decisions coming.
Yeah. I do too. And I believe the legislature returns for veto session in November. So yeah, if it happened in October, I do hear it can be hard to pass things in veto session, especially if something like this, which has just been struck from the law, or struck from a bill rather, they would have to pass it back through the House and the Senate. But maybe they would have the motivation to do that if we had a ruling this, settled this issue and made it so that they needed to address it. Let's hope that's not the case and that the General Assembly doesn't need to address it. But I don't think anybody on today's call is feeling optimistic that that's going to be the case. Am I right?
I don't think they're good.
I mean, it requires people to pick up their phone and call their state senators and their state legislators if the Supreme Court doesn't act the way they want it to, or rule the way they would like it to rule.
Right.
Now, I will say on that, I'm worried about what the Supreme Court's going to say in Molina. I guess I'm worried just in general about this setup, burnt versus raw. But when the Supreme Court makes a cannabis decision that has Fourth Amendment implications, that does get the Chicago Tribune to write about it. Local newspapers write about it. And I don't really trust reporters to get legal stories right most of the time, but if you got the Redmond decision 1 week and the Molina decision a few weeks later, they're going to have to explain.
Yep.
Well, okay, so what the hell did the Supreme Court say here? And I'm guessing 99.9% of Illinoisans have no idea that there's this odor-proof container law, but this will at least, someone's going to have to read the opinion, and maybe a reporter is going to call a local lawyer and say, "Can you walk me through this?" But if the average Joe out there says, wait, you're telling me that it has to be in an odor-proof container, what's the point of that? And now I can get my car searched for if I have weed because it's not an odor-proof container. And what about all those times I've gone to the dispensary and bought a pre-rolled joint and my whole car smells? This is no good. And then that's where the phone calls to the state senator and the state rep come in that Bob was talking about. So the silver lining here, my hope is that even if they do, assuming they do affirm the 4th district, at least that will give a boost to this issue that couldn't come from anywhere else.
Yeah.
Because I don't see how any average Joe out there agrees with this odor-proof container law.
Right.
Anyone who's, I can see how some people think marijuana should have remained illegal and there should be no quarter for marijuana users. But if you're a somewhat reasonable person, I don't know how you can think that this is a good rule.
Mm-hmm.
Maybe they just sell bags that say odor-proof on them so people can have a good faith basis to believe they were odor-proof, even if they're not.
Right. Maybe
That's good.
Yeah.
And then the cops have a good faith exception to search your car. Anyway, so.
Yeah.
Yeah. And, Evan, and I'm sure Evan agrees with me, Cole. We haven't said this before, but we are not giving legal advice at this time. The law is a very special thing that requires sitting down with a client and talking. So please don't take any of the things we're saying as advice legally in your own particular case, because I guarantee it'll be different than what we're talking about.
Yeah, and I'll make sure to put a disclaimer at the beginning of this episode so that's very clear. And, one of the points you've made in the past on the show, Evan, to some people, that may not care about this issue or that may not even be aware of this issue is sometimes people might ask, how hard is it just to follow the rules, which has always been the case, as you said. How hard is it just to not possess cannabis? How hard is it just to not use it? It's like, this is a non-violent crime. And right now it is a crime. And that's the problem. You know what I mean? Yeah. Any other thoughts on this? I had a few questions for you just off, just generally speaking before we close. But any other topics on this Supreme Court ruling, any bases we hadn't really touched yet?
No, I mean, there was only one thing, but I don't know if this is the right time to talk about it. Evan, I'm curious if why would Justice Holder White not be a part of it when she's quoted taking questions and asking them at the oral argument? What's that all about?
That's a really good question. I hadn't thought about that. She was
on the argument.
Yeah.
But she took no part in the decision. I don't understand that.
That is a very good point. I just totally glossed over that. Yeah, she was there asking questions.
Yeah.
So what is this?
Maybe, I mean, maybe it was revealed that, I mean, she came from the fourth district, so she wouldn't even have been possibly involved with any of these players before she got on the Supreme Court.
Right. Redmond's a third district case.
Yeah, so maybe she found out that someone involved was a prior.
You mean
I
a
don't know.
disqualification? She recused herself. It doesn't explain that at all.
It's
No.
not like she's out sick, right? I mean,
I don't know. I just thought that was curious.
that is very curious. I hadn't even noticed that until you pointed out. Yeah, so that is interesting.
Very interesting.
What were you going to ask, Cole?
Oh, I just these kind of questions were a little bit not so much focused on the topic, this particular topic. I did just bring this up, and I guess I wanted to just ask you both, aside from this crime, which I've heard you both have experience with. I've interviewed people that have been charged with this crime of not having an odor-proof container. If folks want to listen to it, you can go to thecolememo.com/isitlegal. It includes other people that have been affected by the continued criminalization of cannabis in Illinois. You can hear their stories. I guess I just wanted to ask you, aside from this particular part of the law, are there other ways that you continue to see people getting charged with, first and foremost, I'm thinking nonviolent cannabis related crimes like cultivation of cannabis, for example. I know that's not legal for everybody. But also just like what, do you represent a lot of people with the drug war? So it's kind of drugs in general. Do you see a lot of drug related crimes in general? Just simple possession and stuff. And so I guess it's a little bit of a twofold question. How do you see people? Do you see people getting charged with cannabis crimes still? And then also just kind of a general curiosity about the drug war in and of itself in Illinois.
Bob?
It varies from county to county. That's for sure. Some counties, which have interstates flowing through them, like I-80 or 39 or 50.
Oh, did we lose Bob?
Either that or he's just being very still.
Yeah, I think we may have lost Bob.
Well,
yeah, if you want to take over.
My answer to your question was, fortunately, I don't see a lot of people charged with cannabis. See it sometimes, usually people have pounds. But I still all the time see people having their cars searched for the smell. So the issue we've been talking about today is fresh and relevant. There's a reason why the Illinois Sheriff's Association cares so much about this, because the smell of cannabis is like the skeleton key that gets cops into cars, probably more than any other probable cause factor. But most prosecutors you talk to nowadays just say it ain't worth the trouble to go after people for small possession, even if it's a little bit over the limit. We're just not. It doesn't have the payoff for us. But I'm sure there's some counties where if people get messed with and harassed, and for those people, it is very real and still a very big problem.
Yeah.
Welcome back.
Yeah.
Sorry, guys, I lost you. I think I was in the middle of saying it depends on which county you're in.
Right.
Counties that have the interstates going through them are the ones that you're going to see, some of the larger narcotics trafficking, cannabis trafficking kind of cases occur. That's not to say that a county like Cook County does not prosecute cannabis cases. They still have them. You'll still see reports where people are pulled over because of the smell of cannabis. What will happen after Redmond? It'll be interesting to see the rulings on the motions to suppress statements. But you know, uh, technically that opinion which just came out, I don't even know if the rehearing period is passed and all that. I mean, I think it's good law right now, but it could be subject to rehearing. I don't know. What do you think, Evan? I haven't done that much appellate. I haven't done any appellate practice before the Illinois Supreme Court.
I suppose you can always ask them to rehear the case, but I think that's about as rare as snow in July. I don't think that's
Yeah.
likely to happen here,
Yeah.
especially with, you know, uh, I mean the defendant's happy, and I don't think the state, it's not like the Supreme Court really missed something obvious. I don't think so.
Right, right. But I mean, what I'm saying is that if you're in a trial court with a motion to suppress pending on a, 200-kilo case, I'm sure the court's going to wait 30 days before granting the motion based on Redmond.
Oh, yes, yes. I'm sorry, I misunderstood the question. Yeah,
I think they're going to wait
the
for
trial judge would wait.
yeah, I
We've
think they're
got-
going to wait for the ink to dry on that before they're going to rule on something as conclusive as that. Yeah, or as dispositive.
Well, or they'll just say, motion to suppress denied, good faith exception. The officer was operating under the law as it existed at the time.
Right. And it's interesting regarding the good faith exception. It was waived in this case on appeal twice. They specifically mentioned the fact that the good faith exception was forfeited. It wasn't waived, it was forfeited twice. So whether in another incarnation of this case, they may raise good faith as an exception, that's still a possibility too.
Yeah.
Yeah.
Yep.
Yeah.
Um,
So just to your point, real quick to wrap up, Attorney Galhotra, you mentioned Cook County. The Chicago Tribune found in the first year of legalization, I think it's, by the way, I'm going to start calling it taxation and regulation of cannabis instead of legalization, because I feel like they get misunderstood when you say legalization. They think that means complete decriminalization. It's like, no. We've got a system to tax and regulate cannabis, and you can purchase small amounts of it, and be careful while you're possessing it, by the way, because if an officer can smell it. Anyways, though, in the first year of legalization, as they call it, there were high arrest rates for Black people, and the University of Illinois actually did some more research, and I'll have a link to an interview here with a researcher who found that data was still true, I believe, in the second year of legalization. And what they had actually found is that these arrests continue in areas without dispensaries, which coincidentally are the areas that have always borne the brunt of the war on drugs.
Yeah, yeah. Yeah, Cole, one other thing you have to remember is when you see repeatedly police officers saying that they pulled a car over and then smelled this burnt cannabis, and that's why they conducted a search. It's not necessarily additional cannabis they're looking for.
Right.
In Chicago, for example, the primary purpose is usually to take guns off the street. That's what they're trying to do. They're trying to search for handguns, and sometimes there have been some notable instances recently where it's been pretty aggressive. Some of these teams that go out try to pull cars over just because they think they may have a gun, and the reasons they pull them over and the pretexts they use.
Yeah. So I asked this question last time. We kind of stumbled upon it this time. And Bob, actually, last time you mentioned you'd done something with a case and you were able to kind of minimize the charges as a result of hemp. Right now, I just was thinking about it. This joint is THCA flower, so it's hemp. When I light it up right now, it's going to smell like weed, which obviously, I guess my point is, I know that the legislature has tried or is going to try to regulate these products, but the bottom line is hemp will still be legal. It just may, if you sell it or whatever. Does that add does that make your job easier at all? I mean, do you kind of get what I'm asking? It's like this weird wrinkle.
I mean, it's hard to discern. I don't know how an officer would discern the difference between Delta 8. I had a case, like I told you, where my client was saying it was Delta 8. And after pointing out the Farm Bill in the Industrial Hemp Act and the requirements, we discovered that the Illinois State Police Crime Lab does not quantify the amount of THC, so that you can't tell whether or not it even would qualify for industrial hemp. It's just a litmus test, basically, for lack of a better word, to see if it is THC or not the percentage. Which which really starts complicating things, because of, if we're talking about the smell or raw or whatever, because raw or smell, it's still going to smell like cannabis that's regulated. But the bigger thing, of course, is the economic thing, is all the dispensaries and the cultivators, and the cannabis industry really wants to protect what it has and doesn't want to have the Delta 8, which is creeping into their market and taking away their profits. So it's really, and I think the government is trying to assist them in that. And we've seen some bills last spring, or this spring, which were trying to hash that out, and there was a lot of expectation, but then it all came to naught, and it didn't really happen, right?
Yeah. Yeah, like you say, I mean, it's not only the products themselves, which we've had operators on the show. Charlie Bachtell, who is the CEO and founder of one of the biggest cannabis companies in the United States, and they're founded here in Illinois. He says, these are truly identical products by people that did not have to go through all the licensing fees and compliance and everything else that we have to go through. And they just open up a shop. And it's really like, a good analogy I heard was taxi medallions and Uber, where it's like the city gave you a taxi medallion, and then all of a sudden the cell phone came around, and it's not illegal to hail a ride from a stranger, right?
Yeah.
And so it's like I think it's a good analogy here. And to that analogy, it's like Uber obviously needs a lot of improvement because there's little to no regulation there. And I think with hemp, this same argument could be made, but more to your point, putting regulation aside, like you say, it's been a direct challenge to this idea of limiting the number of participants in the market. Because I've interviewed the head of the Illinois Department of Agriculture, and he was like, Cole, if you would have applied for a hemp license this morning, you'd be walking out with one. And that's not the way that it is in the cannabis industry. Like, you got to know somebody to get one. And I don't mean in the government. I mean somebody that has a license, because they're not issuing anymore.
You gotta hire Tom Howard.
That's right. You have to hire somebody like Tom Howard, exactly, a cannabis industry lawyer. Shout out to him. He's been on the show a few times. But, to your point, it really challenges that model they have, which is that you can only go to a dispensary to get it. Now you can go to places like Benny's in your corner store, and that really challenges the entire brick and mortar model on which this economy is based on, really.
Yeah.
I mean, So, but again, another topic for another day. I was only asking because I was curious. You had mentioned that last time. I didn't know if time had gone on, if hemp had made because the reason I find it so interesting is there's no possession limit with hemp. Like you said, it smells the exact same as cannabis. So it's like it addresses all these issues I have about the shortcomings of legalization,
Yeah, Evan, I don't know how many criminal defense practitioners actually challenge the chemist from the crime lab that comes in cannabis cases. I mean, usually when you get that far along, you're at trial. This is not usually something.
Yeah.
And when it's at, it's pretty high stakes when it's at trial, because then all the offers to reduce the case and all that have gone out the window.
Mm.
And if you lose, you're going to get close to the middle of the range or max after a jury trial.
Yeah. It also kind of matters at trial in a way that it doesn't add a motion to suppress. It'd be like if you had a solo cup in your cup holder filled with Odors. If you're charged with having, illegal transportation of liquor, you can beat that at trial by saying that was a non-alcoholic beer in my cup holder. But that doesn't, but as far as the cop's concerned, it's beer, and there's no way for him to know it's not. And so he gets to search your car because it's probable cause. But I mean, it's two different questions: trial and whether the cop was allowed to search based on it.
Yeah, that's a good point. You're not going to beat the ride. You might be able to prove it down the road, but
Right,
yeah. So, all right. Well, cool. Well, we covered a lot of bases. I'd love to maybe do a short recap. Hopefully in the next month, if they issue that ruling with both of you. Any parting thoughts before we go?
I think we covered it from my end.
Cool.
Yeah, no, we've covered it extensively, Cole. Thanks for the opportunity.
Yeah. Thank you both.
Thanks.
And we'll see you on the next episode of the Cole Memo. Take care, Bob. Take care, Evan. We'll see you.
Thanks, guys.
So,
Take care.
yeah,